Well, the court approved a termination of benefits that have been paid for over 14 years based on a policyholder's volunteer history and part-time work. Clients often ask me whether or not they should volunteer while collecting their disability benefits. They want to make a difference in the community. And unfortunately, I have to tell them not to volunteer and not to do potential part-time work. Why? Well, let me tell you the story of Brian Kopesky, who was injured in a motor vehicle accident. He was assisting a driver who had driven into a ditch, and Kopesky was struck from behind. He sustained a post-concussive syndrome and a traumatic brain injury. He was a director of North America SAP Integration Office for Kimberly-Clark, a highly intellectual and demanding job. Now, Aetna paid him his long-term disability benefits from September 30, 2004 until February 21, 2018, at which time they decided he didn't meet the definition of disability anymore. Aetna determined that he could do any reasonable occupation, and of course he appealed. Ultimately, this case ends up in federal court in Wisconsin. It's called Kopesky versus Aetna Life. Now, Kopesky had started a charitable organization called Mighty Hearts International to make a difference in the lives of children in Peru. He would regularly meet with 2 other members of this organization, and he would do so on a monthly basis. He would spend an average of about 5 hours per month on the work for this organization. Now, that led Aetna to do a medical review, and it was done by Liar for Hire's medical reviewers. They opined, of course, he could do sedentary work. Somehow, that limited part-time volunteer work became an ability to do sedentary work. Aetna rejected the medical records of his physicians, opinions, letters contesting the denial, and affidavits of people who would attest to the medical problems that he was having and functioning. Now, Aetna said, look, we think that the part-time work and this activity is inconsistent with your claimed disability. Now, what did the court do? Well, the court rejected his argument that there was a moving target for the standard of disability, when in fact nothing had really changed medically at all. Unfortunately, the court disagreed and held that the decision was not what's called arbitrary and capricious. That's a horrific standard of review in an ERISA disability plan or policy. You have to prove that the decision is unreasonable. Otherwise, the court has to defer to this wrong decision. If there's a reasonable basis, liar for hire opinions, potentially the court is going to uphold the denial. So please don't give your disability carrier or plan a reason to deny your claim by doing volunteer work. If you have any questions about your rights to disability benefits, contact me today at 727-894-3188 for a complimentary consultation. I look forward to helping you get the disability benefits you deserve, regardless of where you live in the United States.